Okay, we have looked at the category of land use, what constitute land. Now we are looking into the last part of the land law, which we're going to deal with is the registration of title. Okay, this is governed by section 340 actually. Okay, especially on the indefeasibility. Now, section 206, subsection 1. For registration of title, you must prepare all the proper instrument signed by those parties and attested. Attested meaning somebody witness the proper execution of those documents. Now, memory of the dealing in the RDT and sealed by the relevant authority here means basically when you register, there will be the registrar's document of title. Everything will be in the land office. All the information will be given in those documents. Okay, and then section 89 says that every RDT, which is registrar's document of title, duly registered shall be conclusive evidence that the title to the land vested in the person named therein, of the conditions, restriction and interest and other provisions specified. So basically, these are the things. What you have on your hand is the IDT, or what we call individual document of title. So although is whatever is in the RDT is reflected in the IDT, whatever in your hand. So if you have IDT and RDT, the conclusive proof or evidence of ownership is actually in the RDT, which is in the land office. Okay, in the case of Muhammad Buyung and Pemungut Hasil Tanah Gombak, it says here the memory of transfer duly endorsed but not signed by collector, there will be no registration that can be taken effect. Okay, when we talk about registration of title, we need to see what does it mean by registration. What will be the effect? Okay, the person named in the registration will acquire indefeasible title, meaning nobody can challenge. Okay, now section 340 subsection 1 says the title or interest of any person or body for the time being registered as proprietor of the land or in whose name any lease charge or easement is for the time being registered shall, subject to the provisions of this section, be indefeasible. So basically, whatever they registered will be indefeasible. Indefeasible title means the proprietor title to or interest in the land is unchallengeable, unimpeachable or unquestionable by adverse claim not stated in the register. So no one can claim, okay, that the land is his except for that particular owner whose name is on the title. However, okay, there will be exception. The title may be defeated or set aside. This is provided under section 340 subsection 2, where there will be 3 situations where the title will be defeated or set aside. First one will be fraud or misrepresentation. Second one, registration was obtained by forgery or void instrument. And lastly, the title or interest was unlawfully acquired. Okay. Now, in the case of T.B. and K. Marutamutu, it says in the absence of any of the vitiating factors, okay, if there is no fraud, registration was not obtained by forgery or it was not unlawfully acquired, the registration is indefeasible. What is fraud? Fraud is dishonesty committed by person which caused the registration to take effect. Look at this illustration. A is registered owner of a piece of land. B, by way of fraud, causes A to sign the transfer form to transfer into B. So B registers his title, but A can challenge the validity of B's title. You can look at all these cases. And then, what about registration obtained by forgery or void instrument? Okay, this is governed by section 340, subsection 2b. Forgery, okay, signature was a forgery. Okay, the title will be returned. So this case is Chiu Lip Seng and Perwira Habib Bank. Same thing. This is a very famous case of Aduna Properties and Bunsum Boyanit. The title defeasible and can be set aside if registration was obtained by forgery. If you look at the internet, there's so many issues and stories about this Aduna Properties and Bunsum Boyanit. Okay, or if it's an insufficient instrument, meaning failed to comply with certain formalities. Okay, instrument signed by attorney or has insufficient power. So avoid possibly prohibition imposed by the law. Dealing affected by minor, meaning dealing affected by those who are below 18. So, or if any of this happens, so the title will be defeasible. Okay, and the last one under section 340 subsection 2c. Okay, the title of the to the land was unlawfully acquired. Okay, it says here, for example, in the case of Wong Kim Po and Sama Haji Kasim, transfer was registered while a caveat was still in force. What is caveat? Caveat is a process. Let's say A wanted to sell his land to B, okay, and then when you said a caveat has been entered on the land, maybe A's son entered a caveat on the land because they don't want the land to be sold to B. Probably they think that A is incompetent actually to sign the document. So if the land is still registered under B's name, when the caveat is still in force, the registration will be defeasible. So caveat is to stop the dealing. So in this in our example, if A's son entered caveat to the land, meaning the process of selling from A to B will not happen. So if it still continue, when the caveat is still in force, so registration will be defeasible. Okay. Now, however, what about when A sell to B, assuming if there was a fraud, remember our example here just now, A registered owner, B by way of fraud causes A to sign. Okay. Now, what if in this example, A being the registered owner, okay, A registered owner, B because of fraud managed to actually cause A to transfer the land to B, and eventually B sell to C. What happened? What is the position? Now look at this section 340 subsection 3. What is the position of subsequent purchaser taking defeasible title? So A obtained title from B, okay, or B obtained title from C, whatever, but it has been transferred or sold to C. So what is the position here? What is the position of C? Does C acquire indefeasible title? Yes, if when the title is defeasible, the subsequent owner also take defeasible, meaning you can challenge, right? Unless C is a bona fide purchaser, meaning they buy in good faith and for value. Okay, look at this case. Aduna property. Okay, but we're going to look into that later. But let me just finish this part on section 340 subsection 3. Look at the provisions. Section 340 subsection 3 says where the title or interest is defeasible by reason of the circumstances specified in subsection 2 because of this, okay, because of fraud or misrepresentation or forgery or unlawfully acquired, okay, And then, and any interest subsequently granted thereof shall be liable to be set aside in the hands of any person or body in whom it is for the time being registered. However, provided that nothing in this subsection shall affect any title or interest acquired by a purchaser in good faith. They are talking about a subsequent purchaser, and for valuable consideration or by any person or body claiming through or under such purchaser. This part, okay, this whole part is what we call proviso. So when I say proviso to section 3 of section 340, proviso to the subsection 3 of section 340, I'm talking about this part. Okay, this is where they talk about the position of subsequent purchaser taking defeasible title. Now look at this case, aduna properties. Okay, in this case, respondent was the registered proprietor, which land has been sold and transferred to appellant. Okay, appellant is the aduna. So respondent claimed that the vendor had forged her signature, sold and transferred the land to appellant. High Court dismissed respondent's claim. Decision of High Court was reversed by Court of Appeal and the appellant appealed. So one of the question of law posed for decision was the court was whether appellant or bona fide purchaser for valuable consideration without notice acquired an indefeasible title by virtue of section 340 subsection 3. Now federal court, okay, comprising of panel of 3 judges held that by virtue of proviso to section 340 subsection 3, a purchaser in good faith and for valuable consideration is excluded from the application of the substantive provision of section 340. So therefore, this category of registered proprietor obtained immediate indefeasible title to the land even if they acquired title to instrument of transfer which was forged. Now, this particular issue has been legal issue among the academia, where they said that was wrong. So because of this, a lot of people open to losing their land because of these forged documents. Okay, although many courts reluctantly to follow, but because it was decided by the federal court, they still have to follow the case. Okay, and eventually in year 2000, can't remember what was this year. Okay, but in year 2010, appellant is registered owner of a piece of land. The first respondent purporting to act, executed charges. Now, appellant claimed he did not sign the power of attorney and it was forged. He only became aware when he received letter of demand. So, the principal issue in this case is whether section 340 is confers immediate or deferred indefeasibility. Okay, now in this case, court unanimous decision concluded that the judges in case of aduna properties has misconstrued. So they applied the restated principle of indefeasibility and held that the charges were liable to be set aside. So basically, Tan Ying Hong case give a better decision compared to aduna's properties case. Okay, you can read yourself. So basically, that is all about land law for your purpose, for the students of Diploma in Public Administration and students of Diploma in Corporate Administration. Okay, with that, I thank you. Thank you very much.